Alright, I'm just going to jump right into udaap, unfair or deceptive acts or practices. It's Section 5 of the Federal Trade Commission Act, also included or addressed in Regulation AA, the Credit Practices Rule. Agency guidances on unfair or deceptive lending and marketing practices. OCC Administrative Letter 2002-3, Guidance on Unfair and Deceptive Acts or Practices, and FDIC Financial Institutions Letter 26-2004, Guidance on Unfair or Deceptive Acts or Practices by State Chartered Banks, are all the places where you're going to pick up rulings on unfair or deceptive acts or practices. The federal government began to regulate unfair and deceptive practices in 1914. The Federal Trade Commission Act stated unfair and deceptive acts or practices in or affecting commerce are hereby declared unlawful. The rule was amended in 1938 to allow the FTC to enforce the rule against all entities except for banks. In 1975, the rule was amended again to require bank regulators to address complaints lodged against financial institutions. The regulators responded in 1985 by implementing Regulation AA. Regulation AA applies to all banks and their subsidiaries except savings banks that are members of the Federal Home Loan Bank System. Those savings banks and all savings associations subject to regulation by the OTS are subject to a substantially identical regulation issued by the OTS, which is now the OCC. Regulation AA prohibits certain credit practices that are considered unfair or deceptive. This regulation also requires financial institutions to give disclosures to co-signers of consumer credit contracts. Under the FDIA, Federal Deposit Insurance Act, it sounds like a fiduciary or whatever, but anyway, banking regulators are empowered to enforce any law. Based on this authority, the OCC took action against the bank for violating the FTC Act in 2000. In 2002, the Federal Reserve Chairman Al Greenspan agreed that banking regulators held this authority. Later that year, the regulators began issuing guidance. The OCC was the first to issue guidance on unfair or deceptive acts or practices. In 2004, the Federal Deposit Insurance Corp. And the Board of Governors of the Federal Reserve System issued joint guidance to state chartered banks, also informing them of risks of engaging in unfair or deceptive lending and marketing practices. The guidance is clear that while other consumer protection rules specify actions that banks must take or not take in fairness, for example, FDCPA prohibits certain actions while collecting debts and privacy requires banks to disclose their information sharing practices. The FTC rule remains a general catch-all of the requirement to deal fairly with commercial transactions. Thus, an institution may be in technical compliance with consumer protection rules and still have a udaap violation. On January 29th of 2009, the Board of Governors of the Federal Reserve System and the OTS and the NCUA issued the final amendments to Regulation AA. The Dodd-Frank Act enacted another standard to the udaap laws and regulations, abusive. The acronym is now udaap with an extra A, and the CFPB has administrative authority over udaap laws and has added the requirements to its examination manual. The Bureau also has begun taking consumer complaints on unfair, deceptive, and abusive practices. However, the CFPB has not proposed any udaap regulations. Coverage and definitions. Regulation AA covers consumer credit obligations, which are made to a natural person for the acquisition of goods, services, or money for personal, family, or household purposes. Regulation AA does not include loans for purchase of real estate. Unfair, deceptive, and abusive definitions are covered, I guess. Anyway, consumer complaint provisions, Regulation AA. A consumer complaint is defined as an allegation by or on behalf of an individual, group, or other entity that an act or practice of a state member bank is unfair or deceptive or violates any law or regulation to which it is subject. I can't believe this is not include purchase on. Consumer complaints should be submitted to the Federal Reserve System in writing containing the following: a description of the alleged unfair act or practice, the name and address of the bank, the name and address of the complainant. The Federal Reserve will respond to any consumer complaint submitted in writing within 15 days with either A, a substantive response, or B, an acknowledgement of the receipt of the complaint with an estimated time by which the consumer will receive a substantive response. Credit practices rule requirement Reg A. It is an unfair act or practice for a bank to enter into a consumer credit obligation that contains or to enforce in a consumer credit obligation purchased by the bank any of the following provisions. So you have like 4 provisions here, and I can tell you from a high level, the confession of judgment, the waiver of exemption, the assignment of wages, and the security interest in household goods. So it's confession of judgment is a provision that well, let's just read the definition. It may not include a confession of judgment, warrant of attorney, or other waiver of right to notice and opportunity to be heard in the event of a lawsuit. So that's a provision that just may not be allowed in consumer credit obligations. This prohibition does not apply to executory process in the state of Louisiana. It does not affect confession of judgment executed after suit has been filed for default. Confession of judgment executed after a default occurs. It's not affected, and it does not affect powers of attorney given to a bank or a third party to foreclose on real property, and it does not affect powers of attorney given to expedite transfer or sale of securities pledged against debt in default. And lastly, it does not affect powers of attorney given to expedite disposal of repossessed collateral. Waiver of exemption is another prohibited provision. Consumer credit may not require a consumer to waive property exemptions available under state law. And second, may require waiver of exemption as to the collateral securing the credit. Assignment of wages. Consumer credit may not require an assignment of wages or other earnings unless the assignment is revocable at the will of the debtor. 2 is a payroll deduction plan or other pre-authorized plan the consumer uses to make payments. Or 3 applies only to wages or other earnings already earned at the time of the assignment. And B, the prohibition includes all forms of compensation for the individual services, wages, salary, commission, bonuses, or otherwise, including payments from a pension or retirement program. This prohibition does not prevent legal garnishment of wages. Security interest in household goods may not take a non-possessory security interest in household goods other than the purchase money security interest. However, a bank may purchase another lender's purchase money loan. Household goods do not include works of art, electronic entertainment equipment other than 1 television and 1 radio, antiques, items more than 100 years of age, and jewelry other than wedding rings. Those are all security interests, and really shouldn't be given up. Relating to practices relating to late charges. Here omitting charges. A bank may not collect an additional delinquency charge when the delinquency is attributable only to the non-payment of prior late charges and the payment is otherwise a full payment paid within the due date or the grace period. It does not apply to judicial process of collecting the debt. C. Rules relating to cosigners. Cosigners are natural persons who assume the liability for a consumer obligation without receiving goods or services or money in return for the obligation, or who don't receive the right to use and open an account, and whose signature is required to grant credit to a consumer, not including the signature of a spouse, is necessary to protect a security interest in collateral or as a condition for forbearance on collection of consumer's obligation that is in default. And D, a person who meets the definition of a cosigner is covered by the rules whether or not he or she is noted as such on the credit obligation. Unfair, deceptive practices must not misrepresent the nature or extent of cosigner liability to any person. So, started off talking about prohibitions that to consumer credit, and then I got into pyramiding late charges, rules relating to cosigners, which were natural persons, and then unfair or deceptive practices are rules relating to cosigners. We don't want to misrepresent a liability. We may not accept cosigner signature until cosigner is informed of the nature of liability, and the disclosures required, time and content, and language can be modified to allow for state law or if it conflicts with something else. The disclosure's timing, we must give disclosure to cosigner before cosigner becomes obligated on a debt. And in open-end credit, we must give disclosure before cosigner becomes obligated for fees of transaction. And content must be clear and conspicuous in writing and substantially similar to the notice in the regulation on a separate document, or if in credit document, must be in slightly larger type or set off from other contract language. Additional information may include creditor's name or letterhead, cosigner's acknowledgement, required date notice, date, identity of debt in question, and that concludes that. We have 3 more minutes. We could get into subsection 4 about regulation AA, consumer credit card account practices rule. Could try. The rules cover a natural person to whom is extended a consumer credit card account or who is a co-obligor or guarantor of such an account. Accounts provided to consumers for personal, family, or household purposes under an open-end plan accessed by a credit or charge card. The rules do not cover home equity lines of credit that can be accessed by a credit card or a charge card, overdraft lines of credit accessed by bank guarantee cards or debit cards, and lines of credit accessed by check, guarantee cards, or debit cards that can be used only ATMs, and lines of credit accessed solely by account members. Unfair Act regarding time to make payments. General rule. May not treat a payment as late for any purpose unless the consumer has had a reasonable period of time to pay, and B, institutions must be able to show compliance with this rule, and C, institutions will have a safe harbor for compliance if they mail or deliver taking due statement or bill at least 21 days before the due date. And last but not least, unfair acts, the rule does not apply to the grace period, that is, time the institution allows the institution or the consumer to make a payment without incurring additional finance charges. Now, 2, regarding allocation of payments, when different APRs apply to different balances owed to an account, the institution must use one of the following methods to allocate a payment made by the consumer that is in excess of the minimum payment. A, high to low method. The excess amount of payment is allocated first to the balance of the highest APR, and the remaining portions are applied to other balances in descending order based on APRs, or the pro-rata method, which is the excess proportion of the credit payment is allocated among the balances in the same portion as each balance bears to the total bill. Regarding increases in APR, that's a quick before I get into that.